Friends, it is indeed an opportunity, and I thank you for this honor given to me to speak as a guest of honor on this occasion. The subject of insolvency and bankruptcy is something which is very dear to me, and some amount of crystal gazing and what next in the law is a issue which keeps me going in the context of how the law will evolve, what next will come, and what is the current issue or issues which are likely to get resolved in the short term, in the middle term, in the long term. So, from that perspective, let me start with what I call the SR effect in relation to how the law has evolved or the law keeps changing, and the degree of uncertainty that it brings into play in relation to the closure of CIRP proceedings and the resolution plan coming into effect. Few of you may know that there have been 5 rounds of litigation in the SR matter. It is a case which has gone on for more than 2 years and in some sense has been responsible for the development of the law, but also the failure of the law simultaneously, because new situations, new gaps in the law have come about and have been identified. So what was the main issue in the current round of the SR resolution plan? I think the matter evolves from the National Company Law Appellate Tribunal's decision, which was given in relation to the resolution plan, and wherein for the first time ever anywhere in the jurisprudence of insolvency, the secured creditors and the unsecured creditors, whether they be financial creditors who are unsecured or operational creditors who are unsecured, were treated equally. And that, in a sense, unravels the entire premise of banking across the world, because the pricing in relation to an unsecured loan versus a secured loan is fundamentally dependent upon the priority issues and the higher rights of those of a secured creditor. And if these two are treated equally, then it's a serious issue, and that is what is under consideration now in a civil appeal before the Supreme Court. But considering the kind of clamor and importance of this judgment, the Government of India, in a record time of 13 days from the date of the judgment, amended the law and tried to bring in those amendments which have effectively a fast-track effect and an effect which should otherwise destroy the whole process of what we have achieved in the Insolvency and Bankruptcy Code. So the law was amended in relation to 7 sections, which has been quite a lot of publicity has happened in those, but I will deal with some of these in relation to how the law has progressed and what will be the consequences of those changes. Let me start with the amendment which has been made to Section 5, subsection 26 in relation to how a resolution plan's definition has been modified. And what was the purpose of this modification? We are getting more and more complex resolution plans, and if it is only a straight line approach or a simple one-on-one kind of transition, the best price is not being realized, and in some sense, maximization of value does not happen, because there are multidisciplinary, multi-project, multi-product type of companies which cannot or may not find the interest of a single buyer, and that single buyer also on a going concern basis. Therefore, for the first time in the definition of the resolution plan, it has been clarified that these may include provisions for restructuring of the corporate debtor, including by way of merger, amalgamation, and demerger. Now, this is a far-reaching amendment for the simple reason that the prior regime in relation to restructuring or resolution has been that you can deal with only one company and you can't have a counterpart in relation to how resolution plans are to be structured. So in a restructuring, in a demerger or an amalgamation, there has necessarily to be 2 companies at play. And one of those companies is obviously not a non-performing asset. So this enables the entry of a non-performing asset company which is a solvent company. And therefore, in a sense, the whole jurisdiction of IBC has been expanded to permit a healthy company to be restructured along with a sick company or a non-performing asset. And this is a huge amendment because it's not as if we have too many buyers willing to step in a going concern or in the same company and proceed ahead. People want to chip and chop. People want to come about with different arrangements which have tax efficiency. And all that now will be something which is permissible. This issue actually arose in the Videocon matter where this kind of multi-product situation is there, and one of the requests made was to deal with assets on a separate basis. Now, the other issue which sort of was looming large before the amendment was being worked on was that there are so many cases, including in the Mumbai NCLT, where the admissions take 4 months. In a deadline context of 270 days, the application is not even listed for 4 months. So that's quite a serious issue because this is a time-bound procedure. And if the application itself is not taken up for consideration, then how is the resolution process going to happen? So for plugging this particular issue, they changed the provisions of Section 7 and have brought in the concept of name and shame. So if a national company law tribunal is unable to deal with the admission in 14 days, it has to give a reason as to why the admission has not happened. So in some sense, it brings the clock back to the track. Today the clock is completely haywire, but by this procedure, the effect will be that the process will get, again, accelerated. There is talk among the government circles that we should contemplate a template kind of admission based on form fill and checkbox. So if the form is satisfied, if it is more than 1 lakh of debt overdue, if it is a defaulted debt, then there should be an admission. It is not a matter of detailed arguments like you would have in a civil suit or in a company action. It should be a matter which is automatic, and whatever evolves from that process will be the final resolution. Today, people are contesting the admissibility on the basis that, there are counterclaims, there are these processes. This is not a civil suit procedure. This is a summary process, and it was never contemplated that there would be hearings at admission of this magnitude. The next big change, and which has been the subject matter of the largest debate across India, has been the compulsory completion process in 330 days. How did this figure of 330 days come about? The original contemplation of resolution was 180 days or 6 months. There was an extension right once, just one extension for another 90 days. So that was 270 days. But considering the legal processes and the delays involved in dealing with the matters, an additional 60 days was added to the 270 days, and that's how the position of 330 days evolved. It's not unscientific. It's a process which has been applied because of the cases, the big 12 cases have almost all of them have gone beyond 270 days. The court had developed a doctrine that when it is pending, a matter is pending before the court, then the court time should be excluded. But that is, in a sense, defeating the purpose of the IBC, which is a time-bound revival. And that is one of the reasons why this amendment was brought about. And for pending cases which have not closed because of the resolution plan not having been accepted, they have given a further 90 days period from the commencement of the amendment to close those proceedings. So technically speaking, any action, say even including SR, should be completed now within 90 days from the date the amendment comes into play. There are other aspects which are dealing with home buyers, because what was found was that there was no unison or no single thought, and there were diverse opinions among the home buyers. Some of them wanted refunds, some of them wanted the premises, and therefore how does one vote for such a large class? So the concept of an authorized representative for home buyers was evolved by change of law. And now what has been said is that instead of having individual votes being counted, the majority vote of the whole class of home buyers will be considered as the vote of the class. That is the change that has happened in the law. One of the most important changes, which effectively is an attempt to overcome the SR case, is the amendment to Section 30 of the IBC. And some far-reaching changes have been made in this section, which is effectively to restore the balance between secured creditors and unsecured creditors. But it has immediately raised the issue of fairness to operational creditors in a resolution plan. Now, there's a very interesting legal proposition here that should the doctrine of equality, should the doctrine of fairness apply to a private plan? What do I mean by a private plan? One has to see whose plan is it. It is a plan of a resolution applicant, which is a private plan. It is not a government plan. And in a private party can decide which is the way it wants to distribute the purchase price and distribute the same through a resolution plan. It is not state action. It is consensual action where consent between the resolution applicant and the committee of creditors is effectively evolved. And in a process of consent, which is in a competitive situation, should the court have any jurisdiction to interfere and amend the terms of the bid? Because effectively, the scheme of the statute and the scheme of the regulations is such that there has to be certainty in the bidding terms. Now, if you go on that doctrine, and there are very detailed rules, very detailed timelines, where is the opportunity or scope of a tribunal amending the very basis of the bid? Because if the basis of the bid were to give an evaluation matrix and state that this is the value which is going to be apportioned to payments to secured creditors, this is the value which is going to be given to XYZ factors, then is the court an expert on matters which are financial, concerning the viability of a company and concerning its future prospects so that it doesn't run back into insolvency? Is this a matter of consent? And this question was therefore the issue that the creditors must have a say in a credit-controlled process where the insolvency proceedings and the CRP has shifted from a debtor-in-control concept to a creditor-in-control concept. Here the company is being run for and on behalf of the creditors, not for and on behalf of the promoters, not for and on behalf of the shareholders, because the shareholder value has completely eroded. It is effectively a negative value, and it doesn't even carry a right to vote. Once a CRP proceeding comes into play, the law is absolutely clear that the shareholder decisions are not required to support its resolution plan. So if in that context, one has to evaluate this question as to what is fair, I think there is a necessity of having a discipline within the framework of the tribunal process to state that you have to go along with the decision of the creditors. And if you want to prescribe a minimum payment to be made to operational creditors, do it by regulations. Don't have a procedure whereby you unsettle a winning bid and reverse the whole process, because in those circumstances, you will find fewer and fewer bidders willing to sit for a period of 2 years to wait for a final decision on which one should be preferred. So this, in a sense, is the rationale of how the effect of the judgment of SR before the NCLAT is sought to be overridden by the fact that the law has been clarified that with effect from the commencement, the principles which will apply would be those of Section 53, which is the waterfall procedure under the Bankruptcy Code as to what should be the priority of payments discharged from the realization of the sale of a corporate debtor. The other issue which has opened up and which is problematic and which I believe should not have been done is an explanation which has been added to section 30 subsection 2. And it is in fact more dangerous than the original position, because it says, for the removal of doubts, it is clarified that the distribution in accordance with the provision of this clause shall be fair and equitable to such creditors. Instead of saying that this is a deemed fairness, they have said it's a clarification. Now, the moment you put it as a clarification, it gives the handle back to the NCLT to decide whether it is fair and equitable. And that is bringing the whole amendment back to square one. So this, in my view, is going to create issues. It will come up for decision before the Supreme Court, because Supreme Court just yesterday has said that operational creditors can challenge the ordinance, and both the sets of matters would be heard together. Two other changes which were made in the law. One was that despite the finality of a resolution plan on an approval given by the appropriate authority or the adjudicating authority, should be final for all stakeholders. Clearly, the governments were stakeholders in that statutory dues were the subject matter of resolution. But they were still being opposed to on the ground in relation to sales tax dues, mining dues, XYZ kind of arrears on taxation, and attachments were even sought to be made. So the government has clarified that the central government, the state government, and any local authority which is a governmental authority is bound by the order. So this is in a sense what was implied has been made express, so then it can be shown to the authorities that this is a part of law, and under section 238 of the IBC, it is binding on all parties. And the last change, which effectively has a bearing on the process and the creditor control, is that the committee of creditors, in the course of any time in the proceedings, if it takes a decision that we don't want to waste time on a CIRP because it's getting nowhere, they can take a decision to liquidate the company. So it is not necessary for a committee of creditors to drag on the procedure and wait till the entire procedure truly fails, as is happening in SR, but they can abridge the procedure, cut it short, and say, we don't want any more of this waiting. This is the picture which has evolved pursuant to the NCLAT judgment in SR and the amendment which has been made. And the amendment is going to be tested very quickly, because one takes a lot more time to challenge a law. But because the SR case is before the court, the issues which are contra issues, like the operational creditor issues, and which has a universal impact, unlike the home buyers, where the impact is very little, will be tested in the process. There is power in section 30 for the IBBI to make rules and regulations of how the process of distribution to the operational creditors can be regulated. Now, I want to deal with three other issues that arise and which will create future changes of the law. One of the issues which sort of has been forgotten or lost sight of is that the NPA problem was causing issues of how the banks would recapitalize. And these were predominantly the state banks, with some play by the private banks. So the issue of unlocking non-performing assets is ultimately a cure for a government burden. And these are, in sense, government disclaims or government discharges to the extent of the haircuts. Now, if you start interfering in the process of discounting part of the agreed process of how much secured creditors are to be paid, effectively, the tribunals are increasing the burden on the government through its private sector enterprises. The more you cut, the more you have to subsidize or capitalize. And therefore, this is a fine balance which has to be understood by the tribunals, that this is not an ad hoc play which the tribunal members can do. It is not a court of equity. It is not a court where the judge's heart effectively decides the outcome of proceedings. It is a law which has to be rationally applied, as has been done over 150 years since the law of insolvency came into place. The ILFS kind of situation, because financial service providers are not included in the IBC, because a corporate person doesn't include a financial service provider, there is a need to amend the law, at least in the context of CICs or those who are controlling enterprises, to bring them within the scope of the IBC. Just to give an illustration, 348 companies constitute the group of ILNFS. There are only 2 financial companies out of this whole lot, ILFS and IFIN. And they should have ordinarily gone into a resolution for every other company. 346 other companies could have been dealt with in the IBC. 1st of October is the date when the board was substituted. We are now nearing the 1-year anniversary, and we don't see any light at the end of the tunnel, because everything is still open. The terms and conditions of bids, the terms and conditions of properties, none of them have been actually done in a manner as a resolution professional would under operation of law. The board has not been able to gather the vast amount of data that is required to actually make a fair, good sale. Because if it's going to go at an undervalued price, there will again be issues that the sale is as big a scam as the company going under. So in that context, one of the suggestions which has been made is to have a shadow prospectus by persons in management before the company goes into effective default. And that concept would be to put the burden on the prior management to keep alive a 6-month valid prospectus which keeps on getting updated, so that when an RP steps in, there is enough organized material to prepare an information memorandum. This is one of the suggestions which is pending consideration. The context of financial buyers or financial investors, as distinct from strategic investors, has also not found balance in the IBC, because the ability to bundle all the rights which can be transferred to a secured financial creditor or a secured investor has not been really explained or understood by the government from the purchaser's perspective. And this is an area where I see the maximum amount of future change which will happen. The freedom that is enjoyed in a bilateral sale is currently not enjoyable in a IBC process. And therefore you have today funds and other financial investors wanting to avoid the IBC and try and resolve matters outside the IBC. In fact, today's paper mentions that there's a huge war chest which has been made by private equity players wanting to do this process of purchase out blocks of assets of corporate debtors outside of the IBC, because nobody wants to go through the tortuous process of the IBC. The normal principle which the Supreme Court has adopted, and I'm surprised why they have not adopted it in this, is that there has to be a hands-off policy in economic legislation. The issue of the court interfering in a DRT action or a securitization action is completely different. It's non-existent. And when it comes to the CIRP process, everybody wants to jump in and talk about fairness as if it's the government property which is being distributed. This is a private process of a private resolution applicant. It is his decision of how he wants to run the company upon a resolution. Why should the courts, why should the Company Law Tribunal interfere in a process where a private party has taken a decision of how it wants to pay its creditors and how it wants to go ahead? This is a conundrum which I have yet to understand the rationale of. There have been changes in the resolution professional regime, and there is a sudden attempt to actually squeeze their throat by virtue of the kind of organizational structures that have come into place. Now, this is a counterproductive process for the simple reason that they are the persons who have made the top 12 happen. The organizational depth that the accounting firms have is far more than any individual resolution applicant will ever have. And I think the pressure of the total number of licensed RPs is causing a distortion in the manner in which institutional approach to a resolution professional needs to be kept in place. And this will create more distortions, more delays than what is contemplated in the regime. Competition for money. You have, and in today's paper you have, a statement of the great Sarkari sale. If 3 lakh crores of government assets, whether they come from Power Grid, from GAIL, from BSNL, from MTNL, and privatizing or monetizing PSUs, they are going to compete with the proceedings in the NCLT. The money which is supposedly flowing in the money market or the capital market is inadequate. The more you change the haircuts of banks, the more the budgetary input required. Today, the government in its budget has said 70,000 crores will be used to capitalize public sector banks. If the NCLT keeps changing the distribution which is due to the public sector banks as secured creditors, the effect on the money market will be serious, and there will be lesser and lesser companies which will be going into a CRP process. More will move into the insolvency process, affecting employment. So this is a huge cyclical, circular process which needs to change. The challenge of MSMEs, the lack of publicity to those companies which are below the radar, and how it impacts the possibility of a revival of that sector is again a huge issue, and that is going to be probably the most complex aspect of the IBC. Lastly, and this has been stated in the Rajya Sabha debates, that the IBC should not result in an oligopoly. If you see the 12 companies which have been sold, they have been sold to people who already have monopoly power in the market. And the aspect of competition law and adverse economic effect has completely been ignored in the context of these companies, in the guise or in the basis that you need to revive companies, you need to bring them back on the table. But what it does in terms of how scarce resources go into monopolistic hands has not been interpreted. So I expect that the day will come where again the Competition Commission will try and break up these very monopolies which have resulted from the process of IBC. So there is a vast array of issues which is still not resolved, or which is still not under consideration of the government. And all this will come in some form of a sequence, when and if it's a problem-based solution. So they are playing the process in a manner that an issue has arisen, let's resolve that issue. It is not a futuristic plan, it is not looking at a holistic picture, and this is what needs to change in our approach to the IBC. Otherwise, the trend which has already begun of private equity trying to work things outside IBC under the new 7th of July RBI circular will become the norm rather than IBC. Thank you so much.